Hey everyone, Harry here to talk about the highlights from yesterday's hearing. First, kind of a big deal. It's televised and you have a whole hour of watching it as opposed to the kind of quick accounts from reporters, jumping out from the federal courtroom. You see so much, you see the lawyers and the nuances and the judge. That was valuable in and of itself. But this hearing was pretty darn important, even though it's just the procedural question of who's going to be severed. So it also produced a big headline. Patting myself on the back, I can say I was focused on this in advance, but people hadn't been. And that is, they gave their good faith estimate for how long the trial would take, which they hadn't done before, but we knew their previous RICO trials had gone on very long. And here they said, our case alone is going to take 4 months. And that's without jury selection, which could easily be a month or more, and without the defense cases. We're talking about a 6-month process. That is a big fact in this whole traffic jam that is the Trump legal minefield over 2024. If they have a trial, even one that starts, say, in November, and it doesn't end until the spring, the prospects for a second trial that Trump is in really, I think, diminish. But anyway, it's just a big fact to think about for a number of reasons. Okay, so McAfee, the judge, 34-year-old Federalist Society, people were kind of wondering. I thought he was excellent, really prepared, comfortable, fair-minded, poised. That was a really, I think, good surprise. That maybe a bad surprise for the defendants, but he's certainly not pro either side. But he's not someone I think that they're going to be able easily to push around or hope will put the thumb on the scales, as they may hope about Eileen Cannon down in Florida. Anyway, the real first motion before him, this was about severance. And I've talked to you about that, written about it. Basically, severance doesn't follow from a speedy trial or from removal. You need a separate argument from defendants. It's the exception, not the rule. There's sort of 3 factors to consider, and McAfee was all over them. Here's the 3-part structure, and we don't have to go through it all, but the defendant said, all right, 3 doesn't apply, 1 doesn't really make sense, we agree. And they zeroed in on the discussion, and McAfee firmly but fairly said nothing about Powell or Chesebro's motion really justifies any kind of severance from one another. They are the 2 who have invoked speedy trial. Chesebro did it first, obviously thinking he would go alone. In fact, that's the reason I think it's pretty clear he did it, not for the speedy trial. And he is not at all happy to have the harebrained and uncharming Sidney Powell in the boat with him suddenly. But look, that's how this is really a function of it being a RICO case. They were saying, I had nothing to do with her. She had nothing to do with me. The answer is that's right. And that's actually going to be a bit of a challenge for the prosecution, because they say we have to prove, and we're going to prove, and take 4 months to prove the entire conspiracy involving everyone as to each of the defendants, including Chesebro and Powell. But that's going to mean a trial with long weeks of testimony that really don't have much to do with Chesebro and Powell. But that's because of the RICO statute, not anything that justifies severance. They are, as the DA said, evidence is for one is the same as evidence for all, and that's a function of how they charged it. Remember all the discussion before. Would she actually make this a RICO case? She has, and we're seeing the consequences of it. So he thoughtfully but firmly said, nope, you guys are in there together. Basically, all you're saying is you wish, you don't have much to do with one another, but that's not a reason to sever. That's really has to do with the RICO. All right, but that leaves the 17 then, because again, they need some reason to sever. Right now, the only hard and fast date is the speedy trial date for Chesebro and now Powell, starting to pick a jury October 23rd, and they have to be seated, or Chesebro and Powell are acquitted under Georgia law by November 3rd. And they need a reason to be severed. And to my mind, the three basic reasons don't fit very well themselves. And yet it seems like it cannot be that he would permit a trial of all 19 to start so quickly. Bedlam, everyone would be screaming, we don't have enough time, etc. And I think McAfee made pretty clear that is his view as well. First, he said these three factors that everyone focuses on, they're not the universe, right? I have other possibility of discretion, and people agreed with that. And then he just basically said, it just seems unrealistic to me that we could possibly get this done in time, and that everyone would be lumped together. He also raised a thoughtful, practical problem having to do with the removal, because what happens if, I think this would have to be Meadows, but let's say Meadows is approved to remove, or let's say he's not. That means he goes back and he's being tried. It goes up on appeal, which is a many-month process, and they reverse. So Meadows now should be in federal court, but he's already in state court facing the charges. It could be double jeopardy. That could be a mess. So he made a thoughtful ruling there, though that would suggest not starting the second trial until the Court of Appeals has gone through what will be an automatic appeal on removal for all the people who lose. But anyway, you could just see I'm not going that way. He gave, the state continued to say, we want to try all 19 together. That's usually a favorable dynamic for the state, but it would really be a circus here. And he said, I'll give you another chance. I'll give you 10 pages to persuade me, but let me tell you, I'm really inclined. And let me, Harry, tell you that you could tell he's more than inclined, but just about made up his mind. That ain't happening. He's decided on at least 2 trials, which consequences in and of itself, including, a whole sort of dress rehearsal that the 17 will see. There were lawyers for them in the courtroom yesterday taking very careful notes, but at least 2 separate trials. He hasn't ruled that yet, but I think we can conclude that he's very strongly telegraphed that's where he's going. So the ruling is now Chesebro and Powell are together on the speedy trial calendar that they have a legal right to starting October 23rd, unless they withdraw it. Some suggestion John Eastman wants in as well, but his speedy trial clock would now be a little different. Is that a whole different trial? You really don't want to be getting into 3, 4, 5 different trials. I think McAfee knows that, but he does want to get into at least 2. He doesn't want to jam everybody up in October. So after the briefing, I think you will find him holding, that everyone else is subject to a second trial, and that's kind of in the distance, could become way in the distance, and that makes it much less likely, it seems to me, that Trump's going to face justice and accountability before a Fulton County jury in advance of the November 2024 election. Okay, one big day where the teeny little points of the law totally dovetail with huge political events and consequences. That's the age we are now living in. I think it's unique in American history. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.